Hello, everyone. Welcome to another special Talking Feds one-on-one. The Israel-Hamas war has given rise to a lot of impassioned protests around the country and the world, and they in turn give rise to a lot of vexing free speech issues that I wanted to explore, and we're really privileged to have with us probably the country's preeminent First Amendment scholar, especially in these kind of roiled settings. And that would be Geoff Stone. He is the Edward H. Levy Distinguished Professor, Service Professor at the University of Chicago, where a faculty he joined 1973, 50-year anniversary. After being a law clerk to Justice William Brennan. He was dean of the law school, provost of the University of Chicago, and continues to be a very productive First Amendment scholar. Geoff Stone, thanks so much for being with us.
Thanks so much for having me. I'm delighted to be here.
All right, so there'll be a lot of fodder for First Amendment teachers to have for exams coming up, but this is some serious business as well. I wanted to just fire a series of they're not hypotheticals because they're actual concrete events that have been happening the last few weeks, and get your take on the First Amendment implications of them. So if it's okay, I'll just fire away, starting with there's been many. Oh, and let me say one thing prefatory, which is I'm going to ask you at the end to what extent your answers might vary if it's in a private university setting, but otherwise let's just talk about the public square, as it were. All right, and in the public square there's been plenty of instances of people tearing down signs that have been posted with pictures of hostages. You can imagine they're claiming some kind of free expression rights to do so. I wonder if you have a sense of whether there's a clear-cut First Amendment analysis to that kind of conduct.
To the extent we're talking about public places, like your buildings near public streets and so on, yeah. To the extent the city, assuming it's a city, has a law that says no one can remove posters or the like from buildings, that law would be constitutional, and it's neutral with respect to the message being conveyed, which is important in regulating free speech.
Yeah.
And therefore, I think it would be perfectly okay for a city to have an ordinance that says no one may remove a poster that is legally up. So if someone puts a poster on someone else's building, yeah, that could be problematic, of course, and the person who owns the building could remove it. But if the law basically says that you may not remove a poster from someone else's property, then I think that would clearly be constitutional.
Okay, and I guess in a private property there could be possible trespass laws, et cetera, if you don't own the building. Let me ask you, do you happen to know the sort of status of things? So it sounds like it's perfectly constitutional for a state or municipality to make that regulation, and I would think it might fall under sort of general vandalism regulations as is. But do you happen to know whether most municipalities do have such kinds of laws?
I don't know. It has not been an actual constitutional issue up to this point that I'm aware of. And so I don't have any firsthand knowledge of it. My guess is that it would be regarded as essentially a trespass. If you want to put a message on your home, you have a First Amendment right to do that. And someone else could not remove it without it being at least a trespass, as you say, but certainly would not be permissible. Yeah.
About in a sort of public forum, that is a kind of wall that, by practice anyway, people just pin up different signs looking for roommates or this event, and you put that there. Is it generally? It sounds like at a minimum, a municipality can make it illegal to rip down any of those. And am I right that whether or not they have done so, it would be a sort of jurisdiction by jurisdiction analysis that you don't know sort of one way or another.
Well, if it's a government entity
Yeah.
that passes the law that says you can't remove posters or signs from buildings or private buildings, then it would raise a First Amendment question. And it's hard to believe that if it's a neutral rule
Right.
and it applies no matter what the message is, that it would not be constitutional. I think it would clearly be constitutional as applied either to public buildings or private buildings.
Okay, got it. Let me move to another common scenario here. What about there's in the very entrenched and antagonistic kinds of interactions between people on either side, there's often taping of people making public protests. In fact, if I'm not mistaken, I think NYU just opened an investigation. That's a private university. We can get to that. But in general, if somebody is doing anything in public, including a protest, is there some kind of First Amendment issue, or if you know, because maybe it would sound under harassment or whatever, do you know of any reason that it might be unlawful to tape people tearing down posters, tape people having demonstrations and the like?
One could imagine a law being passed prohibiting that, and one could imagine a court saying that that law is constitutional. But most likely it would not be constitutional. Most likely the notion is that you can record things in public without them being subject to government restriction. You can't do it in private necessarily for obvious reasons. You can't go into somebody's home and film something.
Rules of the game.
But if they're doing it in a public place, then basically it's a public place, and therefore people are allowed to record and take images of what's going on in public.
Okay, so you say one can imagine a court, but courts can say a lot of things. Once Professor Stone testifies as an expert, a well reasoned court would find that it's perfectly okay. You can't there's nothing wrong with that.
No, I didn't say that. What I'm saying is I can imagine a court possibly taking that position. But if something is done in public, then you do not have a substantial legitimate interest in preventing people from recording what you do in public. So to that extent, I think courts would say that it's unconstitutional for a state or a city or whatever to prohibit the recording of public activity.
Gotcha.
The privacy interest of the individual is pretty minimal.
Right. I mean, it would seem so. You're out in the public, but there have been claims that, oh, you can't do this and the like. What about there are some of these demonstrators that wear masks, and at least some of the people on the other side say that those are meant to be, say, as with Ku Klux Klan hoods, are meant to be instruments of intimidation, or just the hiding of an identity. Would there be, again, in a public setting, not in a private university, a First Amendment issue with the banning of masks by demonstrators?
I think that would also violate the First Amendment. The First Amendment respects the privacy of individuals, and obviously there are lots of circumstances where wearing a mask is a reasonable thing to do if you feel that if people can identify you, you can get in trouble. They can punish you. They can beat you up. And therefore, wearing the mask is a way to be effective in your communication. To the extent the circumstances are such where they are understood to be, say, a threat, that would be conceivable, but highly unlikely. But basically, I think in a public place, individuals do have a right to wear a mask as long as they are doing so in a way that is designed to prevent other people from knowing what they're saying. I mean, you could write anonymous op-eds, for
Right.
example.
Yeah, that's right. It's almost like Publius, or the court has said, I believe, that you can be has rejected challenges to say contribution laws that permit anonymity by the donor. So I guess it's a similar principle.
Right.
Even if it's vexing or frightening to some, someone's well within their First Amendment rights in shielding their identity, however.
Right. I mean, as I said, you can write op-eds and you can write leaflets without identifying yourself, and that's part of the First Amendment right of not being chilled in saying what you want to say.
And this must have come up, Jeff, in cases involving, say, the Ku Klux Klan. What about masks that are alleged to have inherent kind of intimidation or terroristic effect? I assume the analysis is unchanged, but if that's part of what's happening here, actually to cow and frighten people with different views, it's never the anonymity principle nevertheless remains. Is that your sense?
In general, one can wear a mask to protect one's identity because people are chilled from saying what they want to say by the fear that others will punish them in one of many, many, many different ways if they know that they hold certain viewpoints, even though they have a First Amendment right to express those viewpoints. So in that sense, anonymity is important to a full-scale free speech. So if one wants to wear a mask while engaging in protest, for example, that would be regarded as protected by the First Amendment in the same way that writing an anonymous letter for publication in a newspaper would be protected. With the Klan, the argument is that the wearing of the mask is the equivalent of a threat. And that even if nothing is said that would itself constitute a punishable threat, the argument might be that the wearing of the mask itself is an implicit threat to others. And it would be conceivable in certain circumstances where that might be taken to be the case, that wearing the mask might be the equivalent of saying, I'm going to kill you if you're Black, right? And to that extent, it's at least conceivable that it could be perceived as a threat. But those would be very rare circumstances.
Maybe another way to put it is, I mean, if someone is reasonably perceiving any conduct by a speaker as being threatening, we're now over the line into a different sort of speech analysis, or it's the threat that becomes regulable. Is that
right? But the difficult thing with a mask is demonstrating that it's in fact a threat.
Right.
But if it says on it, I'm going to kill you if you're Jewish, that would be a threat, obviously. But the mask itself is not the reason for that.
And let me, so can I generalize what you've just said to, I was just wondering, again, in the public sphere, is there any, let's say I'm going to kill you because you're Jewish and Hitler was right, or the equivalent for, kind of vituperation directed toward Hamas or Palestinians? I assume that there's no speech so nasty, you might not invite the speaker to your party, but am I right that there is no, in the absence of an independent crime, basically anything goes as far as words, even the nastiest things that, the most vile expressions of discrimination and the like. Is that fair?
Well, I mean, the court has recognized that threats are not protected by the First Amendment. The problem is defining what one means by a threat for purposes of the First Amendment. And the court actually, this past term, had a case in which it addressed that question.
Right.
And it said that at the very least, you had to be reckless in not being aware that what you were saying would be taken as a real threat by a reasonable person. So if you said to somebody, I'm going to kill you if you don't give me your money, that's a threat.
And it's speech, but nevertheless, it's regular.
Right. But the court has recognized with certain categories of speech, like threats, that are not fully protected by the First Amendment. And so if the threat is relatively explicit, at least to the point that it would be reckless not to know that it would be interpreted by someone as a threat, then it would be protected.
Potentially. But we're again into the threat analysis. So words that don't portend actual threats, but are, extremely vile, as you were saying. Well, Hitler was right? It doesn't, or anything, or what, Palestine should become a parking lot, whatever. That's, unless it's it has to be and I know the court was thinking about from whose point of view does one interpret, but basically in the absence of some showing that it's a threat directed at the listener, that's First Amendment protected, even if not somebody you want to have in your dining club or whatever. Yeah. Okay. Let me well, in this general category, what about this? There are, and this is kind of an old paradigm, but sometimes these groups clash, and somebody is there. Maybe it turns on who has a license, but are there any limits on a group's drowning out speech? In other words, if two are is there any kind of ability to regulate a group that is just saying louder than the other group? You can sort of fill in the blank, but it would otherwise be First Amendment protected. Is the drowning out a sort of separate First Amendment analysis?
Yes, a city or a state can have a law that says that if individuals are engaged in a lawful protest or lawful event involving speech, that it's illegal to impair their ability to exercise their First Amendment rights. So if someone is having a protest in a public park and other people turn on loudspeakers very loud so as nobody can hear whatever they're saying, right, they could be punished for that, consistent with the First Amendment.
And what would the punishment? Would it be public nuisance? Do you know? I know it's not strictly speaking a First Amendment question, but what would be the nature of the violation?
Well, it could be defined as a public nuisance, but they would argue, the people being punished, but we're exercising our First Amendment rights.
Exactly, yeah.
Right. And so the response to that would be, no, the First Amendment does not include the right to effectively prevent others from engaging in their First Amendment.
Okay. And does that include, so you could have the loudspeaker very loud. You could also have a confrontation. I mean, we see this in abortion protests, say sometimes, that it's not exactly drowning out, but you're really in the face of people who are speaking and trying to shout them down or do the equivalent. That is whether you're measured in decibels or not, that's an instance of the same kind of problem. Is that right?
Yes. I mean, if you can prove that people are effectively attempting to prevent those who are exercising First Amendment rights from being able to do so, then the First Amendment would not protect your effort to do that.
Okay. And let's say we have two groups just screaming at each other in the public square. Would it turn on, whose rights are being violated? Would it turn on whether one or the other had a lawful permit to be protesting? Would it turn on who was there first? How would that be considered? Who's the bad guy and who's the speaker?
Well, both of the factors you just mentioned. I mean, if you had a permit,
yeah,
or if you were the first one there and other people were attempting to prevent you from effectively exercising your rights, then they could be punished for disruption of the peace or whatever.
Okay. And all right, so we've implicitly drawn a line between threats, even or it could be assaults, and speech. And I assume that line is analyzed basically in terms of the reasonable apprehension that it can be. You don't have to actually punch somebody in the nose before you're threatening them. So if there's a kind of confrontation where people are really just clearly trying to not just suppress but threaten speech, it's a threat analysis, not a free speech analysis, it sounds like. Yeah.
But it is a free speech analysis, because the question is whether the government can punish the person who's engaging in the speech of threats or whether they're engaged in First Amendment protected speech.
I see. Yeah, you can have a law that said you can drown out Ku Klux Klan folks, but you can't drown out, based on content. What about, I asked you this, Jeff, about the ripping down of signs. You weren't sure of the pattern of laws in municipalities. What about this principle that if somebody is lawfully there, they can't have their speech impaired? Do you happen to have a sense of whether that's a common enacted kind of regulation, or just that if to the extent it's enacted, it would pass constitutional muster?
I think to the extent it was enacted, it would pass constitutional muster as long as it was clear as to what type of behavior falls within that prohibition and how seriously it impairs someone else's speech. But yes, I think it would be permissible to have such an ordinance as long as it was neutral and applied no matter what the message was.
And you're not aware of I'm just thinking, like, what happens now and what officers should actually be doing on the street. You don't know one way or another whether that's a common enactment in municipalities or states, or do you?
Insofar as it's directed specifically at speech, I'm not aware of how many laws are like that. But it would just be disturbing the peace at the very least.
Oh yeah, which is unlawful everywhere. Okay, so let me now, thank you so much for all of this, very illuminating. Let me now switch paradigms and just take it out of the public square and into the Chicago campus, or the private property of a private university, many of whom have speech codes that I think have generally passed muster, but that doesn't mean they can do anything. But well, let me just sort of first serve up a general question. To the extent that is the setting, and otherwise the facts are exactly as I've described in different scenarios, do you have a generalized sense of how the analysis may or must differ?
Well, as a constitutional issue, as a First Amendment issue, the First Amendment doesn't apply. So a private institution is not restricted in any way by the Constitution.
So what we were just saying, you cannot wear a Ku Klux Klan hood, but you can wear any other kind, something that would be flagrantly unconstitutional by a government non-event, or you can discriminate against speakers basis of content, etc.
In terms of the Constitution, yes.
Yeah.
A private institution is perfectly free to do whatever they want in these respects, and cannot violate the Constitution, because the Constitution only protects against violations by government.
All right. And one more hypothetical, which is they have a violation in general against, say, discriminatory speech, but they enforce it only for some kinds of discrimination and not others, flagrantly content unneutral still. And as a constitutional matter, it's impeccable.
Right. But there are statutes.
Right. So now can we move to both statutes and, to the extent they're lawful, and please tell me if I've gotten outside of your strike zone here. As you've pointed out, First Amendment doesn't exercise any do any work here, but there are statutes, and in addition, there are speech codes or policies that universities have passed that have been challenged in court and have generally been upheld. Do you have a sense of, enough to sort of generalize? Because I think there are, a discrete number of variations here about how how the situation differs, or how you would be advising a university president as opposed to a mayor about these different practices.
Well, again, we're talking about private institutions.
Yeah.
They cannot violate the Constitution. That is, they're not capable of being found to have violated the Constitution. Right. Only applies to government. So what they can be held accountable to are statutes, either state, city, or federal, that prohibit certain types of behavior, like racial discrimination, for example. So a private university that says Black students may not engage in protests would clearly violate the federal and state anti-discrimination laws.
Yeah.
Right. Not so much because it's speech involved, but because it's discrimination on the basis of race.
Yeah.
And so those policies would be illegal because of the relevance of statutory provisions, but there has to be a relevant statutory provision. And for the most part, there are not statutory provisions that deal with speech as speech.
I'm trying to think. I mean, I know there are a variety of cases involving private clubs and the like. But all right. So let's leave aside statutes. What about university speech codes? I have a code that's been upheld that generally says no discriminatory speech, and I'm alleged to be applying that in a very slanted way, so that I'm enforcing it as to some discriminatory speech and not to others. No First Amendment problem, but it sounds like maybe there would be a problem under the actual private speech code of the university, but those tend to not be very muscular in terms of the rights they provide the students. Or please, if I'm out of this is part and parcel in the mind, but I know you're a First Amendment expert, not a campus code expert. But
well, I'm also a campus code expert.
Okay, so great. So please,
I'm the one.
You were you had to deal with this all the time, probably.
Yeah, and I wrote
may I just commend the University of Chicago for never having gone down the road that now looks like a bad road of opining on events in the world, like the different Black Lives Matter or the Ukraine war, and now being able to take a consistent position. My son, as I mentioned, is an undergrad there, actually spoke to the president about this because it does seem to many that well, wait a second, this was a problem. Why are you silent now? And Chicago, I think, has been maybe it's a vestige of your time as provost there, but has been very consistent. So I think but that's probably neither here nor there. Tell me about campus codes and what they might prohibit or permit.
Well, campus codes can prohibit, in terms of the law, whatever they want, unless there is a state law that prohibits doing something. So again, a university that says no one can protest in favor of the rights of Jews would presumably violate a state statute against discrimination on the basis of religion. So there are limits on what they can do with respect to these sorts of matters. They are, even as private institutions, they can be prohibited by non-constitutional law from engaging in various types of behavior, most obviously in this context, discrimination. But short of that, the universities basically are free, to the extent they wish, to regulate the speech that's permissible on their campuses, as long as it doesn't violate something like a racial or gender discrimination law.
In which case, they'd run afoul of state anti-discrimination ordinances. Not
right. Exactly. Right. Yeah. But short of that, I mean, they can say no one can criticize the war.
Right.
On our campus, or no one can be in favor of antitrust laws, and you can't speak about that. Now, universities, given their foundational nature, should not do those things. And that's one of the things Chicago has been the national leader in saying the university should not be in the business of saying what types of speech are permissible or not permissible, even if the First Amendment has nothing to do with it.
Or laudable or not laudable even, right?
Yeah, right. That the university doesn't make those judgments.
Yeah.
That this is the whole point of university, to talk about ideas and think about them. And oftentimes ideas we would have suppressed, we turn out that they were right. I mean, think about same-sex marriage as an example, where that would have been something that undoubtedly most universities would have suppressed 50 years ago, 60 years ago, 100 years ago, advocating that. But now, the vast majority of people believe that position was correct. And there's all sorts of examples of that, where if you can suppress things that you are confident are wrong, later you may know, or your successors may know, you were wrong.
Right.
And the whole point of university is to leave those ideas up for discussion and up for debate. and that
I might
universities.
just note your book on World War I, which I've used to teach in classes about security and liberty, really does that to fare thee well with respect to World War I. And well, societies can often be mistaken about it. All right, I wanted to mention, if I didn't up front, you are an unbelievably busy guy for these few weeks, and it's so kind of you to spend time with us. I think I covered the main scenarios I wanted to, but you are, in addition to everything else, just a person observing the different things that are going on with this background of First Amendment expertise. Are there any points that that strike you that we haven't talked about that are worth reflecting on as these impassioned demonstrations continue?
One point I would raise is that there's been a lot of pressure placed on some universities by trustees and donors
Yeah.
to take certain positions. And that's dangerous to the mission and freedom of universities, and it's very troubling. And trustees and wealthy donors should not have the ability to do that. On the other hand, it's not illegal for them to do that, and under existing law, and it puts university administrators in a very difficult position, because even if they themselves are truly committed to free and open discourse on campus, they also need resources, and they need the support of the trustees, and they want to hold their jobs.
And they need not to be public, they don't need to be last in the whole listing like Harvard was for anti-Semitism and the like. But in fairness, some have led with their chin, because the fairly vigorous pushback from donors is, you did it here, so why aren't you doing it there? Another sort of, I think, showing of the overall wisdom of the Chicago principle of not starting there. But that,
Right.
I think it has been hard for some universities to defend, given what happened in the last few years. Which
If universities have these policies like Chicago's,
yeah.
and make clear to people, trustees and donors and alumni, that this is who we are, this is what you should be proud of, this is why you should support us, that probably substantially reduces the likelihood that those people will then argue that you should violate the principles that we think, and we always have thought, are central to the identity of the institution. So I think it's important that universities make clear going forward that these are their policies, and that you shouldn't support us if we don't have them.
Excellent. Geoff Stone, thank you so much for your time. I hope, as other future gnarly hypotheticals arise and you're available, which I know is limited, we can give you a call. But thank you so much for your time today.
My pleasure. Anytime. I'd be happy to be with you.
Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.